said. So what we're going to have a look at today are some tricky clauses in sale agreements, some things that you need to keep in mind and think about when you sign an offer to purchase, what can be done, what can't be done. So what we're going to have a look at, we're going to have a look at when parties sign an agreement of sale, your offer to purchase, and transfer documents when they're not in South Africa. So for example, if you've got a buyer or a seller that is in Australia, New Zealand, America, wherever, we're going to have a look at what we need to do when those documents are signed. We're also going to have a look at when someone signs on behalf of a legal entity, such as a company or a close corporation or a trust. What do we need to do with regards to the person that is signing those documents on behalf of the company or the close corporation or the trust? We're going to have a look at when property is bought in the name of an entity still to be formed that is not yet in existence. Can we do that? Can we not do that? So we'll have a look at that, as well as when the seller or the buyer is a minor. What are the formalities regarding that? And then the 72-hour clause, I'll talk about it, but doesn't really form part of this talk. There's a separate talk with regards to the 72-hour clause, but we can touch on that if you want to. So the first section is when parties sign your offer to purchase, the agreement, and the transfer documents when they are not within the borders of South Africa. Luckily for you guys, your offer to purchase can be signed wherever. It doesn't matter whether the seller or the purchaser is sitting in Australia, New Zealand, South America, wherever. It doesn't matter where they are. You are lucky in the sense that your offer to purchase can be signed wherever. There are no formalities that will have to be complied with. It's as if the guy is sitting in Joburg or wherever, that you have to email the offer to purchase to him. The seller will sign. You will get the document back from the seller that's sitting in Joburg. You then email it to the purchaser in Australia. He will sign the offer to purchase in Australia, and they will email it back to you. You'll print it out or you'll forward it to the conveyancer, and that's it. There are no formalities because that offer to purchase does not get lodged at the deeds office. So there are no formalities with regards to the signatures or witnesses or anything like that. So in terms of our common law in South Africa, any document that has been signed and witnessed in South Africa will be valid for use in South Africa. But the same cannot automatically apply for documents which are signed outside of South Africa. Now, these documents that I'm talking about now relates to the power of attorney. So the conveyancing attorney, when he does the transfer of that property at the deeds office, the conveyancer will lodge the power of attorney whereby the seller of the property authorized the conveyancer, Hein Duisel, to go to the deeds office at Cape Town and to transfer my property of 2695 Gordons Bay to the purchaser being Pipompis. So that power of attorney, if it is signed in South Africa, that's it, beautiful. There are no other requirements or formalities that has to be complied with. If it is executed, signed by the seller in South Africa, that's beautiful. 2 witnesses, and that is it. It gets lodged at the deeds office. It's normally, well, it is when those documents, when that power of attorney is signed outside of South Africa, then it becomes tricky. Then there are certain rules and regulations that we have to follow because the deeds office wants to make sure that that seller that signed the document in New Zealand, that he signed it in front of somebody that made sure of his identity and made sure that this is the actual person that is signing the power of attorney. So they'll check his passport or his ID and make sure that that is the correct person signing the document, that it's not a fraudster. So to make it safe and compliant with our legal requirements, a document signed outside of the borders of South Africa and intended for use in South Africa at the deeds office. So that power of attorney is used at the deeds office. That power of attorney must be authenticated if it is signed outside of South Africa. And we'll have a look, what does authenticate mean? So in South Africa, no problem. There's no authentication. If the person, the seller, signs the power of attorney in South Africa, he will sign it in front of two witnesses, and that is it. That gets lodged at the deeds office. There are no names. Who are the witnesses? Are they commissioner of oaths? No, it's irrelevant. They don't have to be commissioner of oaths, nothing. Notaries, no, nothing. Just two witnesses, and that's sufficient if it's signed in South Africa. However, if it's signed outside of South Africa, it's a different story, because that power of attorney for use is in this connection would be in connection with the registration at the deeds office in order to transfer the property. So again, it does not relate to your sale agreement. Your sale agreement can be signed overseas. It does not have to be authenticated or anything like that, because that offer to purchase does not get lodged at the deeds office. So the parties can sign the agreement anywhere in the world, but the transfer documents, the power of attorney that we need to lodge at the deeds office, that must be signed in a specific manner, authenticated by that authority outside of South Africa. And we're going to have a look at what is the process in order to do that. So, practically, let's say, for example, I get an offer to purchase, and I see my seller is in Christchurch, New Zealand. What I then do is I quickly Google and I have a look whether there's maybe a South African embassy or consulate in Christchurch, New Zealand. Because if there is a South African embassy or a South African consulate, then the seller can go and sign it at the South African embassy or consulate. It's as if he's signing it in South Africa. So that consulate or embassy is the South African one, is South African soil. It is as if he, even though he's signing in New Zealand, in Christchurch, if he's signing at the embassy, it is as if he is signing here next to me in South Africa, because that is South African soil. So again, there's only two witnesses that would witness it, and they will stamp it to confirm you signed it at the South African embassy. There's a little round stamp that goes South African Embassy, Christchurch, New Zealand. There's two witnesses, and that is it. We get the document back, the power of attorney, and we can lodge that power of attorney at the deeds office. The other way, if there isn't an embassy or a consulate close to him where he resides, then unfortunately he will have to go to a notary public. Close to him, wherever in that area that he stays, he will have to go to a notary public, and the notary public will witness his signature. So the notary public will have a look at his passport or his ID. He will have a look at this person sitting in front of him. He will confirm, the notary public will confirm that Piet Pompies signed this power of attorney in my presence in Christchurch, New Zealand, or wherever. What the notary will then do is that power of attorney that was signed by Piet Pompies, the seller, witnessed by the notary public with his stamp on that power of attorney, that notary public will then send that power of attorney to the court. So in South Africa, it will be the High Court that appoints all notary publics. In Christchurch, it would be whoever authorized or appointed that notary public in Christchurch. The notary will send it to that court, and the registrar of that court will go and have a look whether that notary public is in fact a notary public, whether it wasn't just a guy that made up a little stamp for him at the stamp shop and stamped it and now signed it. So it will go to the court. The court will check whether that notary public is in fact a duly appointed notary public for Christchurch and say, oh, okay, yes, John Smith is a notary public for Christchurch, New Zealand, and the court will then put an apostille against that power of attorney confirming that John Smith, who signed as a notary public is a duly appointed notary public for Christchurch, New Zealand. They will then send that power of attorney with all those stamps back to the notary, and the notary will then courier that power of attorney to us that we need to lodge at the deeds office. So it's just a way for the deeds office in South Africa to make 100% sure that that document, that power of attorney that was signed overseas, that it was in fact signed by the actual owner or the seller of the property, that there was no fraud committed, that his identity was checked and double checked by a notary, and by the court then checks the notary, etc. So if you can't sign at the South African embassy or the South African consulate, then unfortunately the seller will have to go to a notary public. The notary public will then witness, stamp, and confirm the identity and signature of the seller. And the notary will then send that document to the court, and the court will confirm, yes, this is the notary public for Christchurch, New Zealand. It wasn't a fake stamp or anything. We can also confirm that this notary public is duly authorized to sign as a notary public, and then we get the document back. In certain scenarios, the document only need to be signed in front of the notary public overseas. The notary public doesn't have to send the power of attorney with his stamp to the court to confirm the authority of the notary public. And those scenarios in the United Kingdom, Great Britain, Northern Ireland, Zimbabwe, Lesotho, Botswana, and Swaziland, if a notary public has signed and stamped the document as a witness, that's perfect. The notary will then send the document back to us. We don't have to wait another 2 weeks for the court to endorse and confirm that this is a notary public. So it's always nice and easy if documents are signed in the UK, Great Britain, Northern Ireland, because then it's just the endorsement of the notary, and the courts or the deeds office in South Africa accepts it. That is a valid document. So that is the scenario, that it is purely for the deeds office to ensure that this person who is selling a property duly signed the power of attorney to authorize the transfer of that property. They want to make sure that if it is signed outside of South Africa, that this is actually the person that signed the document. The owner is the guy that signed the document, and here's the authentication. It was signed in front of a notary public. And over and above that, the court confirmed that, yes, this is a true notary public who was appointed. It's not a fraudulent little stamp. So it's just a way for the deeds office to ensure that no fraud takes place if documents are signed up outside of South Africa. If it's signed in South Africa, no formalities. The seller will sign the power of attorney, 2 witnesses, and that is it. Off you go. So signing outside of South Africa, any document may be accepted as sufficiently authenticated, confirmed, authenticated, that this is the seller, the owner, and that it has actually been signed by the person purporting to have signed such document, that to purport that I am the owner. Double check, make sure notary public gets involved, etc. Speak to your conveyancer so that you are clearly communicate to client or what authentication is required. So again, when obviously your offer to purchase can be signed wherever. There are no formalities. Signed, emailed back to you, great. It's only the document that gets lodged at the deeds office, the power of attorney, that must be authenticated by notaries, etc., etc., etc. If it's not signed at the South African embassy or consulate, then it doesn't have to be notarized. The stamp South African consulate is sufficient to show it was signed in South Africa. Doesn't matter whether it was signed in Papua New Guinea. If it is at the consulate or embassy in Papua New Guinea, it's as if it is signed in South Africa. So no notary, no nothing required. It's a good idea. Obviously, if you know that, let's say, for example, you've got a seller that phones you to come and value the property. The seller gives you a mandate to sell his property, and you know, and he tells you, look, I'm here on holiday for a month now, so come take photos. I'll give you the keys. You can do your show houses, whatever. I'm going to go overseas. I'm going back to New Zealand, and I don't know when I'm coming back, wherever. Tell him, listen here, you're the seller. There are certain documents that you'll have to sign when the property is sold. That has to be signed in front of the notary public, or it has to be signed at the South African consulate or embassy. So you know what? Why don't you give a power of attorney to one of your family members or friends that are here in South Africa? Give them a power of attorney to sign those transfer documents on your behalf so that you don't have to hassle with running around trying to find the embassy, trying to find a notary public that charges money for witnessing £5 per page or whatever. It's costly. So keep it in mind that if you do know that your seller is here in South Africa for a short amount of time, he's going back overseas, wherever, tell him, listen here, contact the attorney that you want to appoint to do the transfer and ask them to do a power of attorney for you, authorizing your brother or your sister or the neighbor. If you trust your neighbor, authorize the neighbor to sign the documents here in South Africa on your behalf so that you don't have that hassle when you go overseas. When someone signs on behalf of an entity, such as a company or a close corporation or a trust, then obviously there are also certain requirements that has to be met. And little things that you must make sure that you've got in place. So, the decision making. Every company, close corporation, trust will have trustees that come around a table and have annual meetings or weekly meetings. So, for example, at STBB, we are exco directors. The managing directors of the company meets every single Wednesday at 7 o'clock at the Cape Town office to make decisions as to what they need to do, what do they need to authorize, what decisions they need to make to manage and run the business. So that is what a company, a close corporation, and a trust should do. They have meetings and they decide to buy or sell or invest or to buy a car, buy computers for the company. Are we going to employ more staff? They make those decisions around the table and they pass resolutions as to what they've decided. The directors or the members or the trustees will sign the resolution that they need to give effect to this decision, and minutes are being kept and records are being kept of the resolutions and discussions that they had and the decisions that were made. So resolutions are taken by means of voting for or against whatever proposal or decision they need to make. Normally, each director has got one vote. Most resolutions are taken by the board of directors by way of a simple majority. So 51% of the directors or members or trustees vote for a specific thing, then that's fine. Then that is what they're going to do. However, other decisions are more involved, it's more complex, and then they need a special resolution, which is 75% of directors must take a decision. And in certain instances, a unanimous resolution, 100% of the directors or members must vote in favor or against a specific decision. The shareholders, so you've got your directors of a company or the members of a close corporation. Very often a company will have shareholders as well. So generally speaking, the shareholders of a company or close corporation, they do not interfere with the day-to-day running of the business, the decisions that are being made by the directors. They don't get involved with that. The shareholders just want to see their profit share at the end of the year. That's all that they're concerned about. They don't care how, they don't get involved with the running of the business. They just want to see that the directors make decisions to the benefit, and if they get their profit share at the end of the year, they are happy. Carry on what you're doing. We're not getting involved with your decision making. So therefore, where a company or close corporation is a party to a sale agreement, whether as a buyer, seller, purchaser, make sure that you get a resolution authorizing the company to buy or sell the property and authorizing a specific director to sign all the documents. So the resolution must state that the STBB registration number had a meeting on the 7th of July 2021 at 10:51 in the morning, and it was resolved by the directors that the property of 2695 Gordons Bay will be sold by the company, and that Piet Pompies is appointed as the director that will sign all the necessary documents in order to give effect to this resolution. And then each and every single director of that company will sign that resolution, and that is Piet Pompies' authority to sell the property, to give a mandate, to sign the offer to purchase, to sign the transfer documents. He has been authorized by resolution. So it's important when you're dealing with a company, close corporation, or trust, to make sure that there is a resolution in place where the company or the CC or the trust has decided to sell or purchase. If the company decides to buy a property, exactly the same, there must be a resolution by the directors that decide that they are going to purchase. The company is purchasing this property. They've decided they want to purchase this property, and that Piet Pompies is authorized to sign the documents on behalf of the company, whatever. So the resolution is very important to have it in place. Sometimes you will see that there's a sole director. So in that scenario, it's easy just for the sole director to sign the offer to purchase because there are no other directors that needs to authorize him. He's the sole director. He signs the offer to purchase and off he goes. But it's good to have that resolution whereby the company made the decision to purchase or sell the property. Then Section 112 of the Companies Act says that if a company sells the whole or a greater part of the assets of the company, then a special resolution must be signed by the shareholders. So this is just, it's obviously in terms of the Companies Act. The Companies Act want to protect shareholders from directors doing whatever they want to do, disposing of the whole or the greater part of the company's assets. Then the Companies Act says, oh, hang on, we need to get the shareholders involved here. Yes, we know that they are not involved with the daily managing and running of the decision-making of the company. That's absolutely fine. But if you as directors, if you're selling all the assets or the greater part of the assets of this company, then we need to get the shareholders in. And the shareholders must authorize this by a 75% majority, that you guys can do this. So that is when the shareholders will be involved. So that's part of the conveyancing process. Part of the documents that we will sign with the company as seller is an affidavit whereby the director who's authorized on behalf of the company confirms whether or not this company, because they're selling this property, whether or not this is the whole of the asset of the company, or if it's a greater part of the asset, he must confirm, yes, it is, or no, it is not. And if it is, then we'll say, well, who are the shareholders? And they often, obviously, there are no shareholders. It's just us directors. We don't have any shareholders. Well, that's fine. Then we don't need a resolution because there's no shareholders that we need to get involved. So if there are shareholders, and if it is the whole or the greater part of the assets of the company being disposed of, then that special resolution that was signed by the shareholders must be filed with the Registrar of Companies. It's normally the accountant that will do that. He will file that resolution by the shareholders. If there are shareholders, 75% voting, he'll file that with the Registrar of Companies. With trusts, so decisions on behalf of trusts are made by the trustees of the trust. One trustee acting on his or her own cannot bind the other trustees. It cannot bind the trust. So again, the trust will have a meeting. The trustees will then decide to buy or sell properties. Minutes will be kept, and they will have to sign a resolution whereby the trustees decide to buy or sell a property and to authorize maybe one of the trustees to sign all the documents. The trust, you have to establish that the trust was formed. So there must be letters of authority. So, for example, if you've got a purchaser and the purchaser says, listen here, we want to buy this property, but we're buying it in the name of a trust that we're still busy forming. And we know it's going to be the Heindesel Family Trust, okay? That's going to be the name. But the accountants are still busy registering the trust at the master's office. But just put the name of the trust along. You can't do that. No one can enter into the name of a trust if the letters of authority has not been issued by the master's office. So make sure if you've got a purchaser that wants to purchase a property, make sure say that's absolutely fine. Can I please see the letters of authority? I just want to see that this trust is duly registered because you can't sign an offer to purchase for a trust that must still be formed. It's impossible. It's against the Trust Control Act, so you can't do that. And furthermore, I need that letters of authority because I, as the agent, want to see who are the trustees, who will be authorized to sign on behalf of the trust. And do you have a resolution by the trust, by these trustees? Because I can see their names here. There are 4 trustees. Where's the resolution that was signed by Jan and Sunny and Magdal? Where's that resolution authorizing you to sign on behalf of this trust? Because I need the letters of authority. I want to see that it's registered and I want to see who are the trustees. And did these trustees authorize you to make an offer to purchase or to sell the property or whatever? So it's important to have the letters of authority and to have the resolution in place, in writing, before the property is sold or purchased. A resolution authorizing the transaction has been signed by all the trustees. That's something that you must check, and that's why I need the letters of authority before the date of signing of the agreement. So the resolution signed after the offer to purchase was signed can be declared null and void in a court of law. And we'll have a look. There is an example of that. A trust is regarded as formed once the master has issued the letters of authority for the trustees. It's like a birth certificate for the trust. Without that letters of authority, the trust doesn't exist. There's no authority. A trustee can only act on behalf of a trust if the letters of authority have been issued by the master's office, and if the letter of authority if the letter of authorities have not yet been issued, the trustee has no authority to act. As a result, it's not possible for a person to sign any agreement of sale on behalf of a trust still to be formed. Such an agreement is invalid. Check the scope of the trustee's authority. So it's important. So, for example, when we get an offer to purchase, and for example, the purchaser is a trust, we immediately write to the trust, the trustee, whose contact detail was inserted in your information sheet on the offer to purchase. We write to them and say, right, can we please have a copy of the letters of authority? Can we please have a copy of the resolution? And can we please have a copy of the trust deed? Because that trust deed tells us as conveyancers what the trust can and cannot do. It will tell us what are the powers of the trustees. Can they buy and sell property? Can they take out a mortgage bond? So that trust deed will show us if that trust deed doesn't allow the trustees to purchase property or to register mortgage bonds, the contract is null and void because the trustee who signed that offer to purchase never had the authority to purchase a property because the trustee doesn't allow the trust to buy property or take out bonds. So that is why it is important to always get a copy of the trust deed as well, to make sure that the trust can buy and take out mortgage bonds on properties. If a trustee does not expressly empower the trustees to transfer property, to register bonds, or obtain loans for the trust, or to stand surety or open bank accounts or whatever transaction is, then they do not have the power. They do not have the power to do so, and the resolution authorizing is invalid. Check the letters of authority that was issued. Make sure that the trust is valid, that it was registered, because again, the trust cannot act without the letters of authority that was issued by the master's office. Insist that all trustees must sign the agreement of sale. If they don't have a resolution, for example, then all trustees can sign. They must all sign the power or the offer to purchase, unless they've got a resolution which is authorizing one person. That's fine then the one trustee can sign. But if they can't produce a resolution, well, trustees, all four of you will all four sign this offer to purchase now, unfortunately. Obtain the resolution before the agreement is concluded. And the convention should request the original or a certified copy of it from the trustees. We'll ask for that from them as well. So we've got an example. So the T Trust existed and there were three trustees. So the letters of authority were there. Beautiful. There are three trustees. Great. One of the trustees, Mr. T, signed an agreement of sale in terms of which the trust purchased a property. Although the other two trustees were aware of the transaction and approved it, they said, no, we're happy with it. He's authorized, that's fine. Their approval was not obtained in writing in a signed resolution. In other words, there was no written resolution signed by the other trustees authorizing Mr. T to sign the agreement on behalf of the trust. Nor was there a power of attorney authorizing him by the other two to enter into the offer to purchase. Then, obviously, as luck would have it, there was a dispute between the seller and the purchaser, the trust, and the matter went to court. And the court declared that the agreement was ab initio void. It was from the outset. From that offer to purchase doesn't mean anything. It is invalid from the beginning. There was never a valid agreement to start off with. It never came into existence because of the two things, the lack of a written trustee's authority or resolution, and which is required in terms of the Alienation of Land Act, which states that all agreements for the sale or purchase of a property must be in writing to be valid. And furthermore, if someone acts as another person's agent in signing an agreement of sale, then that person must have the necessary authority to act as such an agent, and it must be in writing. So it is very important. When a trust buys or sells, there has to be a resolution in place before the offer to purchase is even signed. Because if that offer to purchase is signed by a trustee who's saying, I've got the authority, I've got the authority, I've got the authority, without the resolution, the contract is null and void. You might as well throw it in the bin. So it's important to get the resolution from the trustee who says he's got the authority to do so. The court reasoned as follows. A trustee cannot bind a trust by acting alone. All the trustees must act jointly. And in order for them to act jointly and authorizing one person to present them all, he needs to be authorized to do so by way of a written document, which is the resolution. But because the provisions of the Alienation of Land Act, written authority is required in the case of the sale or purchase of land. So by signing the agreement in the way that he did, without the resolution, he acted as principal for himself, as agent for the other two trustees. The law requires that they should have authorized him in writing to act on their behalf before he signed the contract. So it's important, get that resolution signed before the contract is signed by that trustee. When the property is bought in the name of an entity, that must still be formed. So obviously we know, with regards to a trust, you cannot have an offer to purchase where a purchaser tells you he's buying it on behalf of the Hein-Daisel Family Trust, but that trust is still in the process of being registered. Sorry, Hein, we can't do that. It's impossible. You cannot buy on behalf of a trust to be formed. The letters of authority must be there for you to buy the property in the name of the trust. However, for a company or a closed corporation, it is still possible to buy the property. I, Hein Daisel, signing this offer to purchase, I just want to point out, I'm buying it on behalf of my company, Piggyback CC, that is still to be formed with the registrar of companies. That is possible. There are certain requirements, rules, and regulations that has to be complied with. So what happens if a person decides to buy a property in a company, but the company is not yet created or formed? Obviously, sometimes the scenario exists where I see a property for sale and I know that there's going to be a lot of interest in that property, but I want to buy the property in the name of the company. My company is not registered as yet, they're busy with it, but I don't want to lose out on the property. Then I can make an offer to purchase. I'm Daisel, acting as agent for Piggyback company that is in the process of being registered. It is possible to do that, but there are certain rules and regulations that has to be complied with. It has to be formed in order to become the owner. So it will be formed as soon as it is formed, the company, then the company will ratify the agreement and the company will take over the responsibility of the agent that signed the offer to purchase on behalf of the company. It is necessary to protect the seller in case the company is never formed or is formed but breaches the agreement. So obviously it's a sticky situation with regards to the seller. He's between a rock and a hard place because I made an offer on behalf of a company or closed corporation to be formed, and the agreement will say that the company, once it is formed, must still ratify Hein's agreement that he entered into on behalf of the company. So the directors must go and have a look. Now we formed the company, right? Hein, what did you do? Oh, okay, you bought a property. No, well, we're not happy with that. No, we're not going to ratify that. Sorry. So the whole contract becomes null and void. So it leaves your seller in a bad spot because he doesn't know whether the company is going to ratify, whether his property is sold or not. So, but there are clauses, obviously, that we normally insert into such an agreement. If Hein Daisel signs the offer to purchase on behalf of a company to be formed, there are certain clauses that are inserted in that offer to purchase. For example, there'll be a clause to say that company must be formed by no later than a month after Hein signed this offer to purchase. Okay? So you put a time limit on it so that Hein doesn't drag his feet for the next year to form his company. No. The offer to purchase Hein, that's fine. The seller accepts your offer on your company to be formed. He's happy with it. Okay. But you have to form your company within a month after you sign this offer to purchase. If your company is not formed within a month, then you will become the owner of the property. You are the purchaser. Then we forget about the company, then you're going to buy this property in your personal capacity. And further, if the company is formed within the month, that's great. And we then give the company another month to ratify, to accept the offer to purchase, and to take over the responsibilities in terms of the offer to purchase. And if the company doesn't do that within a month, then you are the purchaser and you're going to take transfer of this property. So that is a way not to leave your seller hanging out to dry. That it takes a year for Hein to go and form his company. It takes another 3 months for them to ratify the agreement, and then they come back and they don't ratify the agreement, and then the seller is back in square one. Then there's no sale agreement, so you must start looking for another purchaser. So there are clauses that you can bring into the offer to purchase to safeguard your seller. So if the company isn't formed, or if the company is formed and they don't ratify, they don't accept this offer to purchase that Hein signed on their behalf, well then I'm sorry for you. You are now the purchaser and you must take transfer of this property in your personal capacity. entity still to be incorporated, there cannot be an acknowledgement of a relationship between a company and its agent acting on its behalf where the company is non-existent. This is a contract purportedly entered into between an agent acting on behalf of a non-existing company. Is a nullity for this reason too, and is incapable of being ratified by the company after it's been incorporated, etc., etc., etc. So there are two solutions to this. Both the Old Companies Act and the New Company Act created a legislative way out by making specific provisions for the entering into agreements on behalf of a company that is not yet in existence, that must still be formed. The Old Act and the New Act says that, and it confirms the common law. The common law says that if the existing option of a stipulatio ulterior, an agreement entered into by two persons for the benefit of a third person. Hein enter into an agreement with a seller for the benefit of a company to be formed. The third person need not yet be in existence when the contract, when Hein signs as purchaser, when the contract is signed. In the discussion below, we are not concentrating on the stipulatio ulterior contract for the benefit of a third. We will, however, briefly highlight the differences between the concepts to enhance clarity as to how the new act and the old act apply. So what happens is, in the new act and in terms of the old act, the act said there that it is possible for a person like Hein Geisel or whoever to enter into an agreement on behalf of a company or closed corporation that must still be formed. It is absolutely possible to do that. However, if the company is not formed or if the company doesn't ratify the contract, then Hein, in his personal capacity, will take responsibility and liability for the obligations in terms of the contract. So it is covered by law that I will then take responsibility if the company isn't registered or if the company doesn't ratify my agreement that I entered into on their behalf when they were still not formed. When we have a look at a seller or a buyer that is a minor, in the eyes of the law, children are for most part not permitted or authorized to enter into contracts without the assistance of their guardians. This is to protect children, minors, who does not have the mental capacity and ability to appreciate the contract that they are entering into. And the law does not want minors to be exploited by unscrupulous contractors and consultants or whatever. So that's why there are certain rules and regulations with regards to minors. So who are minors? Any person is a minor until he becomes 18 years old. Entering into a valid marriage, a minor, if a minor is 16 years or older, a minor may enter into a marriage with the assistance of your guardian. You can get married with the assistance of your guardian if you are 16 or older. So as soon as you are married, let's say you are 16 years old and you get married, you are then seen as a major. You're no longer a minor, you're a major if you are married, even if you're 16 years old. Being declared emancipated, legally capable of looking after himself. So for example, a person that's 15 years old can go to court, to the High Court, and say, court, have a look here. I'm running my own businesses. I'm a successful businessman. I've got X amount of money. I'm looking after myself. I pay for my own food, my own accommodation. I'm looking after myself. The court can then emancipate him. Even if he's 15 or 17, whatever, he will then be seen as a major. So if a 16-year-old person marries, the person will thereafter be considered to be a major and will be able to enter into any valid agreements that he deems fit. It's as if he's 18 years old. A person left school at the age of 15, for example. He started working, he earned money, he lives on his own, he provides for his own needs. At the age of 17, um, he's an astute businessman with proven abilities and wants to rent premises for his expanding business. He applies to the High Court for an order that declares him emancipated, declares him 18 years old and old enough to make decisions as a major. If the court grants such an order, this person will then have um, the majority as an 18-year-old, and he can do and contract as and how he deem fit. So a distinction is made between people that are younger than 7 years and people that are older than 7 years. A child younger than 7 years is regarded as to having no contractual capacity. You cannot sign a contract if you are younger than 7 years. Your guardian, your mom or dad must sign that contract on your behalf. You cannot put pen to paper at all. Contracts may be concluded on behalf of a child younger than 7 years. The contract has to be concluded or signed by the legal guardian. So, for example, Mary Koch, a grandmother, decides to donate her property in Somerset West to her grandson, who's 5 years old, Willie Koch. The boy lives with his mother as his parents were divorced some time ago. In granting the divorce order, the judge awarded sole custody and sole guardianship to the mother for a donation. So even a donation in land, it has to be in writing. So there'll be a deed of donation where the grandmother donates to the son her property in Somerset West, and the donee, the person getting the donation, must also sign, I accept that donation, thank you very much. So in our example, the contract will be signed by the grandmother, Mary, as the donor, and by the boy's mother, because Sarah will have to accept the donation on behalf of a son who's 5 years old, who's got no authority to sign any document. So Sarah, mom, will sign on behalf of the son. Minors of 7 years and older, they've got limited contractual capacity. They may enter into contracts in terms of which they acquire only rights and no obligation without the assistance of a guardian. If a person donates a bicycle to a child who's 10 years old, that child can sign the agreement, can accept the donation on his own because it's only for his benefit. There are no obligations or duties on him. So he, 7 years and older, between 7 and he can sign the agreement on his own. He needs no assistance by his guardian. A minor may enter into an agreement in terms of which he incurs obligations. Absolutely. He can sign that agreement on condition that he is assisted by his mom or dad as guardian. Then he can sign that agreement where he gets obligations. It has to be countersigned by the guardian. So there's another little case study. Willie Koch is now 16 years of age. He was awarded an acting part in a movie, and due to the popularity of the movie, earned a substantial amount of money. In consultation with his mother, he decides to invest the money in property, and they decide that he will buy a sectional title unit in Greenwood. Willie, now being over the age of 7, is able to conclude the agreement, but the law requires that he must still be assisted by his guardian. Accordingly, the contract will then be signed by Willie and duly assisted by mother as guardian, in my capacity as the guardian of Willie. The property will be transferred into Willie's name? Absolutely. It won't be transferred into the mom's name. It will be transferred into his name as a minor. Willie is now 17 years old and he owns a property. He signs an agreement to sell the property, and the agreement will be void as Willie has no contractual capacity to sign. Sarah decides, for whatever reason, that the property should be sold. That's obviously the mom. And that the money should be invested on his behalf, whatever. Will she be able to sign the sale agreement on behalf of Willie, who's still a minor, just her signature and Vili's signature, or just her signature. No, she will not. Um, she will need to obtain the consent of the Master of the High Court or the High Court order. So, for example, if a minor, 17 years of age, disposes of a property, sells a property, and the property is valued for less than 250,000 Rand, the Master of the High Court must still authorize the sale of that property. Doesn't matter whether Vili's mom, Sarah, as guardian, signed the sale agreement and next to him and assisted him. That's irrelevant. As soon as you dispose, a minor sells or disposes a property, you will have to have either the consent of the Master of the High Court if the value is less than 250. If the value of that property is more than 250,000 Rand, you need a High Court order authorizing the sale of that property. Again, it's a way for the Master's office and the courts to make sure that the correct decision is made when Vili or minor disposes of a property. When you acquire a property, happy days. You are increasing your estate. So you don't need the master's consent or a high court order authorizing Vili, duly assisted by his guardian, Mom Sarah. You don't need their authority when you acquire property. Not at all. Buy property as much as you want. But as soon as you sell a property, then the master's office or the high court, depending on the value of the property, will have to authorize that sale of that property. Assuming the masters offer consent or the High Court grants the order authorizing the sale of the minor's property, who will then sign the transfer documents and how will the transaction be described? So if Vili is less than 7 years old at the time that the transfer documents must be signed, his mother will sign the documents on his behalf. He cannot put pen to paper. He is less than 7 years old. If Vili is older than 7 years and signs himself, he will be described as follows. Vili Koch, ID number minor, duly assisted by Sarah Koch in her capacity as the guardian. So less than 7 years, Vili can't sign. He can't put pen to paper. Mom will sign on his behalf, everything. If he's older than 7 years, Vili will sign and his mom will sign next to him, duly assisted by mom being the guardian of Vili. So with transactions involving minors, one sometimes hear in regard to divorce proceedings regarding custody and guardianship. You only need to have a look. The guardian will sign on behalf of the minor child. So whoever was appointed as the guardian in terms of the divorce order will be authorized to assist the minor when signing documents. So the court order will tell you who's got the authority. It's normally both parents, obviously, but it's not always the case. Both parties might have custody, joint custody, 1 week on, 1 week off, etc. But who's got the guardianship? That might just be with the mom, just be with the dad. So when a contract is entered into, you need to go and have a look in the court order as to who can assist the minor child in order to sign those transfer documents. So again, the guardianship is very important, and you will see the guardianship in the court order. Again, there are now examples as to the mom assisted the son, but the mom is not the guardian in terms of the court order. You need the father to sign, or the divorce order says that both parents jointly together must enter into contracts or give guardianship, etc., for important matters. Then both parents will have to sign. So it all boils down to what the court order says with regards to guardianships. Before 1993, it's interesting, the father of a child was normally the sole guardian, even while married or when the parents of a child got divorced. Guardianship was given to the father prior to 1993. How shocking. How things have now developed that both parents are now seen as guardians of the child unless the court order stipulates otherwise. And that is it, guys. Do we have any questions? I'll quickly have a look here. Thank you, Michelle.
Thanks, Hein. Doesn't look
Over
like
to
there
you,
was any
Todd.
questions, but thank you for a very comprehensive